Hi everybody, this is the ninth lesson for Legal Studies 3-4 and the final video for Unit 4 Area Study 1. In today's video, we're going to be covering the High Court's interpretation of Section 7 and Section 24, referendums, the High Court's interpretation on the division of powers, and external affairs. The High Court's interpretation of Section 7 and Section 24 feeds off of the High Court's role in acting as a guardian of the Constitution. So remember that as the High Court seeks to protect the Constitution and enforce it, the High Court has the ability to interpret the meaning of the Constitution and modernize that to a 21st century context. That, remember, is without changing the specific wording of the Constitution and just changing its application. So through the High Court's interpretation of Section 7 and Section 24, the High Court has actually created two implied rights, which are implied from the text of the Constitution and not expressly written in the Constitution. So Section 24 states that the members of the House of Reps are to be chosen directly by the people, while Section 7 states that members of the Senate are to be directly chosen by the people. And so the rights that have been implied from the sections act as a restriction on Parliament's lawmaking abilities, more so than an individual right for civilians. So the first right that the High Court has implied from the text of the Constitution is the implied right to freedom of political communication. So the High Court has confirmed that because we need to be able to elect our members of Parliament, we need to be able to discuss political matters freely. And without this implied right, we would not be informed when voting in elections, and we wouldn't be able to choose candidates who actually represent our views and values best. And so this was upheld in the case of Lang and AVC, which upheld the existence of the implied freedom of political communication and also broadened the context of this right. So Lang confirmed that this was not just a right at the time of elections or just prior to elections, but this is actually a permanent right that we are able to freely discuss political issues. And so the Lang case concerned the former Prime Minister of New Zealand, and the ABC features a report suggesting that he was corrupt. And so Lang sued for defamation, but the ABC argued that this information was important as it related to political issues, and it was, essential to representative government and allowing people to elect politicians who represent their views and values. And so the High Court ruled in favour of the ABC and confirmed this ongoing freedom. So even though Lang wasn't currently running for an election, he was involved in political issues and political affairs, and therefore the right to freedom of political communication was confirmed, because this communication indirectly involved elections and therefore was essential to representative government. However, the Lang case did confirm that this right to freedom of political communication can be limited by Parliament in some circumstances, but you don't need to worry about that too much. So just know that it is a permanent right, but it's not an absolute right, that it can sometimes be limited by Parliament. The second implied right that Parliament that is a limit on Parliament that the High Court has confirmed from the text and structure of the Constitution is the implied right to vote. So because we need to be able to choose members of the House of Reps and the Senate as per Section 7 and Section 24, there is an implied right to vote. And so Parliament cannot interfere with our ability to engage in politics and choose representatives who best reflect our views and values in Parliament. So the case which confirmed this right to vote is the Roach and Electoral Commissioner case. And so this concerned the Electoral and Referendum Amendment Act, which banned all prisoners from voting. And so Vicky Lee Roach was a prisoner, and so she had standing because she was directly affected by this issue. She was unable to vote in the election. So she initiated a claim in the High Court and the High Court held that prisoners serving sentences of less than 3 years were eligible. And it was inconsistent with the right to vote to deny all prisoners the right to vote, because that meant that the phrasing of Section 7 and Section 24 to be chosen by the people wasn't actually upheld. It was just people who were not prisoners. So in order to ensure that the people, including prisoners, were able to vote, they made changes to this legislation and said that you can't restrict all prisoners' right to vote, only prisoners who are convicted of serious criminal offences and receive sentences of more than 3 years. So the High Court confirmed that the right to vote could be limited in circumstances such as serious criminal misconduct, and therefore it was justified to restrict a prisoner's right to vote if they were sentenced to over 3 years imprisonment. The next dot point we need to focus on is referendum. So this ties back into the double majority dot point that we looked at in the last video. So remember that as per Section 128 of the Constitution, referendum is the only way of changing, modifying, and adding something into the Constitution. And this ensures that people have a direct say by ensuring that a majority of people vote yes, and a majority of people in a majority of states vote yes. And so remember that referendums give power to the people and restrict Parliament's ability to change our rights. So here are two examples of referendums. The first referendum, the 1999 referendum, shows how referendums protect our Constitution. So in 1999, there was a referendum which posed the question of whether Australia should become a republic and leave the constitutional monarchy of the UK and instead become completely independent and have a president instead of a prime minister. So this was rejected and only received 46% of votes and not a majority of states. So the double majority provision was not satisfied. And so we remained a constitutional monarchy. And so this shows how when things are not in the people's interests, we are able to protect our Constitution from being changed by Parliament. The second example is the 1967 Aboriginal referendum, which shows how referendums can be used to make necessary changes to the Constitution. So prior to the 1967 referendum, Constitution denied Parliament the ability to make laws regarding Indigenous people under the race power and did not include them in the census, which meant that resources were not properly allocated for Indigenous people because they weren't considered in our population statistics and that kind of thing. So these were clearly discriminatory clauses that needed to be changed. And so 90.77% of voters voted yes to changing and removing these sections of the Constitution, and all 6 states voted yes. So this was a successful referendum which satisfied the double majority provision, and as a result, the race power was changed and it deleted Section 127. So this shows how the people can have power to change the Constitution when necessary. The next dot point to consider is how the High Court's interpretation of the Constitution can sometimes shift the division of powers. Remember, the division of powers is the jurisdiction of state and federal parliaments to make laws in specific areas. So Section 75 of the Constitution outlines that the High Court can hear matters where the Commonwealth is being sued or is suing another party, or between states, disputes between states, residents of different states, or a dispute between a state and a resident of another state. Essentially, the High Court has the jurisdiction to hear all matters arising under the Constitution. So where there's any issue regarding the Constitution, that case will be heard in the High Court. So the High Court has a history of interpreting the Constitution in a way which shifts the division of powers by giving the power to the Commonwealth at the expense of the states. So an example of this is the case of the Queen and Brisbane, where the High Court was required to interpret Section 51, and Section 51 outlined that the Commonwealth has the power to make laws on postal, telegraphic, telephonic, and like services. So Brisbane was charged under a state legislation for not having a license to operate the radio. And she argued that the legislation was invalid because the Commonwealth did not have the power to make laws for such a radio. And so she argued that it was invalid for the Commonwealth to make laws regarding radios, and therefore invalid for them to charge her for not operating a license to operate a radio. Because it wasn't specifically listed in the Constitution prior to this case, it would have been assumed that this was a residual power. Remember, residual powers are everything that is not specifically listed in the Constitution as a Commonwealth power. So because it didn't specifically state radios, Brisbane argued that radios were a state power and the Commonwealth had no lawmaking jurisdiction over radios. However, the Commonwealth argued that radios fell under the phrase telephonic and other like services. The High Court interpreted the phrase other like services and ruled in favour of the Commonwealth. Although the decision did not change the wording of the Constitution, it established a precedent that radios are other like services under Section 51. And so radios were no longer considered a residual power. They were now considered a concurrent power because both states and the Commonwealth could make laws regarding radios. This, therefore, extended the lawmaking powers of the Commonwealth at the expense of the states, because the Commonwealth now had the power to make law for radio. And if the Commonwealth made laws for radio and the states made an inconsistent law regarding radios, the state law would be rendered invalid under Section 109. The final dot point to look at is the external affairs power. So under Section 51(29) of the Constitution, the Commonwealth Parliament has the power to create laws in relation to external affairs. External affairs simply meaning international issues, things that are external to Australia. And this provides the power to the Commonwealth to give effect to international agreements such as treaties and declarations. And so the Parliament can make laws regarding to international obligations under treaties which Australia has ratified, even if the subject matter of that treaty is not a power of the Commonwealth Parliament. So as per Section 61 of the Constitution, the executive has the power to enter into treaties and declarations, and those treaties are ratified once they are passed by both houses of Parliament. Once the treaty is ratified, Australia therefore has obligations under international law to fulfill. Therefore, Parliament has to create the laws to give effect to those international obligations and international laws. There are two different types of international law that are important to note here. First is international treaties, which are a binding agreement between countries that form international law. The second is international declarations, which are non-mandatory and are more so considered to be influential intentions, but they are not binding and mandatory. However, both treaties and declarations enable Parliament to give effect to international affairs. So if the Commonwealth entered into a declaration, even though it's not binding and Australia ratified that declaration, the Commonwealth Parliament therefore has an obligation to give effect to the declaration obligations. And that extends the power of the Commonwealth, because the Commonwealth can now make laws to give effect to that declaration, even if the subject matter of that declaration was not a power of the Commonwealth previously. So this ensures that the powers of the Commonwealth are expanded at the expense of the states, because let's say the Commonwealth entered into a treaty about lighthouses, which was previously thought to be a residual state power. The Commonwealth, through the external affairs power, now has the ability to make laws regarding lighthouses, even though they were previously a state power and could only previously be exercised by the state. So this is a great case to show you the application of the external affairs power, and that's the Commonwealth and Tasmania. So this was where the High Court was required to interpret Section 51(29). And this issue arose when the Tasmanian government wanted to dam the Franklin River, which was considered to be an area of residual power regarding the environment. And so this was considered to be something that only the Tasmanian government could make laws upon. However, the Commonwealth argued that it had a duty to stop work that would damage or destroy Australia's heritage under World Heritage listed sites. And so the Commonwealth passed the World Heritage Properties Conservation Act in order to try and prevent this damming of the Franklin River. However, the Tasmanian government argued that the Commonwealth legislation was invalid because environment was a residual power, and the Commonwealth therefore had no lawmaking authority to pass the World Heritage Conservation Act. However, the Commonwealth argued that the Commonwealth Act was in fact valid because the World Heritage Properties Conservation Act was giving effect to Australia's external affairs and obligations under the World Heritage International Treaty. And even though environment was previously considered to be a residual power, because Australia had ratified the World Heritage International Treaty, the Commonwealth now had an obligation to fulfill those obligations and could therefore pass laws regarding the environment. The High Court upheld the Commonwealth's argument and held that the Tasmanian government's decision to dam the Franklin River impacted upon heritage listed land, and therefore it fell under the external affairs power because it affected Australia's obligations under the World Heritage International Treaty. And so therefore, the Commonwealth Parliament was able to make laws in areas of the environment despite not having any power under the Australian Constitution. And that was because it pertained to external affairs and Australia's international obligations. And just to finish off, these are just some limitations of Australia's obligations when giving effect to external affairs powers. So laws passed by Parliament cannot go beyond the provisions of the treaty. They must fall within the scope of the treaty. So if the international treaty is about lighthouses, the Commonwealth can't make a law about boats and argue that it was under the treaty. It has to be specific to the treaty subject matter. The treaty must also have been bona fide, which means that Australia must not have entered into the treaty just to gain lawmaking powers and restrict the state's lawmaking powers. Australia must have entered into the international agreement and treaty because they genuinely want to, improve international law or improve Australia's obligations in regard to external affairs. It can't just be a greedy attempt to grab power over an area of law. And furthermore, the Commonwealth Parliament cannot give effect to treaty obligations which may express one of our 5 express rights. So, for example, we can't sign a treaty that says the whole world is now going to be a certain religion and then start passing laws to impose a Australian religion because that breaches our express right to religion, freedom of religion. So that brings us to the end of Unit 4, Area Study 1. I hope you found this video useful, and I'll see you in the next one.